Hey there, folks. Bill O'Leary. And in this video, I'm going to be answering the question, how should I own my car if I'm married or if I have a young child driver? In this video, you're going to learn three things. Number one, the right way and the wrong way for a married couple to own a car. Number two, the liability exposure that a parent has when their young child starts to drive. And number three, what can be done to limit the liability risk. Let me quickly introduce myself before I get started. Again, my name is Bill O'Leary. I'm an estate planning, elder law, and probate attorney, and my firm is Legacy Planning Law Group in Jacksonville, Florida. So let's first talk about a married couple. Are you married? Chances are you own your car together as husband and wife. Sounds like the right way to own your car, right? Wrong. Let me first tell you what happens generally when spouses own assets together. This is generally now. They're protected under the law. And what that means is if just one of you gets sued, that then the assets you own together jointly are protected. So in the eyes of the law, the asset is not owned by two people, but by an indivisible unit of one. And since both of you didn't incur the liability, both of you are not on the hook and your jointly held assets are protected. Now, there's one big exception to this law. What happens if you own a car jointly as husband and wife and one of you gets into an accident? Now your joint assets are no longer protected. They're exposed to the lawsuit. Ouch. So what can you do to limit the exposure? Make sure that you don't own a car together jointly. And if you do, take one name off the title. So let's say you own two cars, figure out who the primary driver is of each vehicle and title it in their name. Now, the other spouse is certainly able to drive the car, the spouse that's not on the title, that's fine. And if that spouse causes an accident, the liability to the owner spouse will be greatly limited by certain monetary caps under the law. The exposure is limited, the current cap being about $850,000. And by the way, don't get confused with the words and or on the title. You might think that just by putting both of your names on the title as or, that it solves the problem. It doesn't. Safe thing, just get both names off the title so you end up with just one. Now, let's shift to talking about kids. If you have a minor child who's about to start driving, you need to be very careful. Before a minor child can get a driver's license, a parent or guardian has to sign a parental consent form where the parent accepts responsibility for the minor's driving activities. If the minor then is negligent in operating a vehicle, the parent is responsible. And by the way, there are no caps or limits on the parent's responsibility. Compare this to the situation I just mentioned where of a married couple where one spouse owns a car and lets the other spouse drive it. Or let's say that you're married and you own a car and let somebody else, let's say a friend or family member, drive it and they cause an accident. Although you as the owner have responsibility, there are at least monetary caps under the law for that liability. Well, those monetary caps don't apply to a parent of a minor who has signed the parental consent form. Now, if a minor child has two parents, do both parents have to sign the consent form? The answer is no, only one does. So a good planning strategy is to have the spouse with fewer assets sign the consent form. There's less at risk. And make sure that the other spouse, the one with more assets, does not have their name on the car title. So this way, if a minor child causes an accident, fewer assets are exposed to the inevitable lawsuit that seeks damages over and above the insurance coverage limit. Now, let's fast forward when the minor reaches age 18, the liability that the parent took on when they signed the consent form goes away. So that's a good thing. However, it doesn't mean the parent is necessarily off the hook for liability. Even where the child turns 18, a parent can still be held responsible under something called the dangerous instrumentality doctrine. And this is a law that says that the owner of a vehicle has to make sure that the vehicle is operated properly. And if they let someone else drive it, but where they knew or should have known that this other person would be careless with the vehicle, then the owner is on the hook. This is called negligent entrustment of a vehicle to someone else. And here, there is no liability or monetary cap that's imputed to the owner of the car. So what can you do to limit exposure? First, review how your vehicles are owned. Look at the title for each car. And one option is for the parent to take their name off the title and just place it in the sole name of the now legal adult child. Now, there is one hiccup that you may run into: car insurance and the cost of it. That cost may get very expensive if an 18-year-old is solely on the title. And so if that cost is too much, and if you're married, another option is to make sure that both spouses' names are not on the title. So if you feel like at least one spouse's name needs to go on to make the insurance affordable, that's fine. Just use the spouse's name who has fewer assets. One other thing you should do is review your insurance. Make sure that at a minimum, you have enough insurance to cover if you do have the benefit of that $850,000 monetary cap, that you have enough insurance to at least cover that amount of damages. And don't forget umbrella insurance, because remember, if you're married and you own a car together, or if you negligently entrust your car to someone else, there is no monetary cap. So umbrella insurance, it's a great inexpensive way to get additional protection over and above the car insurance you have, so you can sleep well at night. So if you would like to know more about how you should own your car if you're married, or have a young child driver, and maybe how we can help, we'd love to talk to you. And so we would invite you to go ahead and book a free 15-minute phone call. We call it our discovery call. And it's a chance for you to tell us what's on your mind and for us to start a conversation. Scheduling could not be any easier. So go to the bottom of this video, and there's a link. Click on it. It's a scheduling link. It takes you straight to our scheduling booking calendar, and just pick a time that works best for you, and we'll jump on the call. If you'd also like more information about other topics relating to estate planning, maybe elder law or probate, you can subscribe to our YouTube channel, Legacy Planning Law Group. And if you've enjoyed this video, please like it, better yet, share it with your friends. So this is Bill O'Leary signing off for now. And until we talk again, go make it a great day and a better world.